Now moving on to the next speaker, we have Senior Advocate Mr. Shyam Divan. Again, Mr. Shyam Divan is one of our Vice Presidents. He is also the President-elect of Law Asia. He has written books on environmental law, which we all as students have read. He has also taught environmental law at graduate and postgraduate level at University of Mumbai, and has also occasionally lectured on the subject at the NLSE National Law School of India University at Bangalore, as well as at National Judicial Academy, Bhopal. Besides representing in pro bono capacity various citizen groups in many litigations, public interest litigations on environmental issues. Mr. Divan, please.
Hi, Justice Goel. Thank you very much, Anindita. I sort of leave the river for a moment and talk about someone else who required help yesterday in the Supreme Court, and that was the great Indian bustard. So we've got this magnificent bird. It's one of the heaviest birds which is capable of flying, and it's on the brink of extinction. And the reason why I raise this in this opening remark are there may be more than one way of ensuring that we protect the types of resources like rivers that we're speaking of without necessarily conferring on them personhood or a corporate status in terms of, as was mentioned, recognizing them as some sort of a legal entity. To complete on the bustard, the challenge just now is to protect an order which was passed last year in April by the Supreme Court. The Supreme Court followed on an order which had been passed earlier by the National Green Tribunal. It went a little further in saying that there will be no future overhead transmission lines because to prevent collisions as far as the bird is concerned, and further that all those lines have to go underground. Now the objective, and this is what I'll come to link it up with rivers, I think we need to be fairly clear as to where we want to go and whether conferring status, legal status or personhood insofar as a river is concerned in the eye of law, is that a good strategy, and is that a good strategy for here and now? The objectives are fairly clear. I think in the Indian context we need some experimentation, we need some improvements in how to go about our business. The reason I say that is that we've had, say, the closest to water regulation, we've had a national law on the statute book since 1974, and it's been a pretty dismal failure. So we need something new in that regard. We're not very successful with regard to air pollution either. But in water, if you see the surveys which have been carried out, there has been very, very little improvement in terms of the manner in which we administer and control and regulate pollution. The latest effort which we know about is the National Green Tribunal Act of 2010, and the idea is to give an impetus by having an expert body which can sort of drive and prod agencies in trying to improve the water quality. So I think pollution and water quality is clearly one area. Mr. Katarki mentioned another, ensuring minimum flows and ecological flows. A third is, of course, the whole range of ecosystem services which rivers render and advance. The fourth is ensuring that we have some sort of a framework in anticipation of the huge changes which climate change is apt to bring. Almost every model shows that we are going to have huge or substantial changes in precipitation patterns across the Indian subcontinent. And how is that going to impact us is something which we need to consider in the context of whether we should be giving legal status insofar as rivers are concerned. At some levels in India, we are just one Supreme Court judgment away from a very well established legal principle. So it's the Indian Supreme Court, particularly in the field of natural resources and environment, is never very far from taking a huge advancement or a stride in terms of jurisprudence. And so, if you see the acceptance of many principles that we have, polluter pays principle, to some extent intergenerational equity, but most certainly sustainable development, the public trust doctrine, precautionary principle, all of these have entered the statute book via laws of Parliament after the Supreme Court articulated these principles in judgments and applied them across the board. So at one level, all it's going to need to confer legal status on a river is one Supreme Court of India judgment, probably from the Uttarakhand decision. So Professor Bakshi says that, look, we have a caste system in the Indian judiciary, and the caste system is that you cannot say anything has come from the high courts first. It has to come from the Supreme Court of India. So, I mean, that's a sort of a cultural disadvantage that we have over here. But if you look at, for example, the evolution of public interest litigation in India as well, you find the real initial work, whether it's in the field of environment in the Silent Valley case in 78, or whether it's in the good governance principles, it was the Bombay High Court in 1975. Those were the courts which developed the principles initially, and I'm hopeful that maybe the National Green Tribunal, rather than the Supreme Court of India, will really now push the envelope in terms of better, sounder river jurisprudence in terms of ensuring ecological integrity. So that said, in terms of we are just one judgment away, how hopeful or confident am I that that judgment is likely to come? Frankly, there is a lot of unlearning that the Supreme Court of India has to do in the field of environment. And possibly amongst the most regressive judgments, I hope this is permissible, one of the most regressive judgments from an ecological integrity point of view for the subcontinent is a judgment of the Supreme Court on interlinking of rivers. So instead of the usual process of having a government project, proposal, testing it out, having ecological impacts, we have a sort of top-down approach where the Supreme Court of India picked up a news article, appointed a amicus curiae. The President of India at that time had said that, look, interlinking rivers would be such a grand idea, forgetting the problem. So, I mean, as an engineering solution, it may be wonderful for overcoming a large number of our water crises. But in terms of just the ecological integrity of this vast subcontinent, it can be fairly harrowing unless you do the studies and move forward. So anyway, this is a huge roadblock, one, in sort of conferring persona for rivers. Second, I think at the moment at least the government thinking is to push forward river interlinking, at least in a small way, not in the grand manner as laid out in the Supreme Court of India judgment. This will of course be tested, and I'm sure there will be a rethink in many respects with regard to some of the standard and basic ecological elements. But that's something again which you can't do if each of your rivers is a persona and is going to say that, hey, I'm not interested in interlinking anymore. So given the government compulsions, given the Supreme Court dynamics just now, at least in the near term, I don't see this particular position being accepted. But I do see, and I think I'll be very positive on this, I do see situations like, again reverting back to the Great Indian Bustard, where the court recognizes someone to champion causes which the government may not be entirely alive to and sensitive to project them in through the decision making process, which is essentially what we want, because at the end of the day I think we want, as a strategy, improved decision making when it comes to this very, very important natural resource of our rivers. Thank you very, very much.
Thank you, Mr. Divan. Your one of the statement when you said, can the river really say that, hey, I don't want to flow? That was in fact one of the queries that came to our mind when we were reading the judgment, because again, talking about rights, there are layers of rights. Are we talking about legal rights? Are we talking about constitutional rights? Or are we talking about fundamental rights? Because there are orders and orders where in some places very loosely the expression fundamental rights have been used, somewhere constitutional rights have been used, and somewhere now and we are talking about legal rights. So I think the layers of rights and the implication of that we need to discuss, and that requires a further detailed discussion and debate, and hopefully in near future we'll have that as well. Thank you, sir, for that wonderful speech. Now we will have presentation by members of the TISS project team from New Zealand and Colombia. So we will now have Dr. Elizabeth from New Zealand. She has her research interests are in indigenous and environmental rights to natural resources in comparative context. She has particular interest in indigenous rights to water in Australia and Latin America. Dr. Elizabeth, please.
Hello everybody, and thank you very much for this invitation. I would like to acknowledge all of my colleagues from the Indian Bar Association who are here, the President, the Honourable Justice, and all of the rest of you. I'm really pleased to be able to talk as part of this important presentation. So I am an associate professor at a university in New Zealand, and my field is environmental law, and I'm going to talk a little bit about the model that the President actually introduced quite well already, knows quite a bit about, that came out of Aotearoa New Zealand in 2017 with relation to the Wanganui River, which is a legal person. And I'd like to acknowledge that I have my colleague with me in the audience, Miriama, who's actually from the Wanganui tribe and the people who drove that model. So we're really lucky to be here today and learning about rivers and their protection in India too. So what the President explained is that the New Zealand case arose out of a negotiated settlement between the Crown and a particular tribe, the tribe that lives next to and is very closely interconnected to the river for its livelihood and also its spiritual and cultural beliefs. And the way that the Wanganui tribe view the river is encapsulated in the quote that I have up here on the slide, which is from the Waitangi Tribunal's report into historical grievances experienced by the people with respect to the river, which happened in the 1990s. And in that tribunal decision, the tribunal is explaining that the way that the local people view and relate to the river is quite different to the way that our water laws and our environmental laws have traditionally framed human interactions with rivers, which is very much that rivers and water resources are things that we use and things that humans are completely separate to, rather than something that we are dependent on and perhaps ecosystems that we form part of. So because of the challenge that the Māori worldview poses to the usual approach of the laws, we needed a new law, and we needed a settlement that was going to try and look at things differently and do things differently. And we've had presentations that have talked about this today, this need to frame our relationship with rivers differently. And that is what happened in the settlement for the Wanganui River. So if I could move to the next slide. So what we ended up with in 2017 was a piece of legislation, so not a decision of the court, but a piece of legislation in which the river is recognised as being an indivisible and living whole from the mountains to the sea. So it's very much an integrated ecosystem-based approach. And it includes the physical state of the river, but also the spiritual and the metaphysical nature of the river too. So there's, a correspondence and a relationship between what we've heard in terms of the belief systems in India with respect to rivers. If I look at the next slide, so this is what we know from the New Zealand case, that the river is declared to be a legal person with the rights, powers, duties and liabilities of a legal person, and that there is a human face that's created to represent the river and to advocate on the river's behalf. And this is what a lot of people know has come out of the Wanganui case, but it's a lot more than this. It's really providing for a collaborative governance framework for the river, which is led by the iwi, the tribes, but involves a whole lot of other users and people who live near and depend on the river, who come together to make decisions that are better for the health and the well-being of the river. So if I go to the next slide. And that decision-making process is based on 4 values which are provided for in the legislation. They come from the customary law, or the tikanga Māori as we say, of the iwi, and I think that they're the most important part of the legislation actually, because these are the values that we're working towards in decision-making that affects the river. And those values recognise that the river is interconnected with the health of the people, that it itself is integral, it can't be managed in a way where we think about impacts on water separate from the banks, separate from the land next to it, separate from the resources in it, which is the way that our laws have always approached things. We need to take a more holistic approach and a more ecosystem-based approach. So it's much more than just declaring that a river is a legal person. It's actually providing for a collaborative framework for the people who care about the river in place to make decisions about its health and well-being. The only thing else I would like to say before I let the next person speak, if you have a look at the next slide, this model for the Wanganui River is just for one river in New Zealand, but there are similar models for other rivers throughout New Zealand which don't involve legal persons, but do involve collaborative governance regimes. And it's also now had an influence on our national policy framework for freshwater management, which adopts a principle called Te Mana o Te Wai, which is about putting the health of the river or the health of water before other interests. And on the next slide, you can see the hierarchy that's provided for in the policy framework here, that the health and well-being of the river comes first, and then you have the health needs of people, and then you have social, economic and cultural well-being. And the only other thing, after saying I wasn't going to say anything else, is that we're currently in New Zealand going through a reform process for our entire environmental law system. And on the next slide, I just have a reference to what's going on at the moment. We have 3 new pieces of legislation being proposed, including a Natural and Built Environments Act, a Strategic Planning Act, and a Climate Adaptation Act. And all of these laws embed this relational approach, or they're proposed to embed a relational approach in which the health of the environment is put forward before other interests, because we can't really have anything else if we don't have healthy ecosystems. So that is me, thank you, and I've really enjoyed the presentations and look forward to hearing more in my time here in India. Thank you.
Thank you, Elizabeth. Now we have Dr. Catalina from Colombia. She is a lawyer from Colombia. She holds LLM and MA in Peace Studies and a PhD in law. Currently, she is pursuing her postdoctoral studies on polycentric climate governance in action, study of interaction between Norwegian and Amazonian agricultural policy for climate change. Dr. Catalina, please.
Thank you so much, Anindita. Thank you, everyone. It is a pleasure to be here and listen to you and know more about the Indian ways and perhaps future ways of protecting rivers. It is a pleasure for me as well to share some words about the case of Colombia, which is slightly different from the New Zealand case and also a little bit different from the Indian case. So just to give a little bit of context, Colombia is a republic, democratic republic, who got independence from Spain in 1810. And we have a rather recent constitution. So the most recent constitution is from 1991. In this constitution, there is a human right to a healthy environment. There is a human right to health and protection of human right to life, but there is no rights for ecosystems or rivers. In this legal context, we also have a little bit of a messy context, as you may know. We have a political armed conflict going on for over 60 years with different attempts of ending it. And this conflict is somehow related to inequality in Colombia. So as we got independence from Spain, in Colombia we have ethnic diversity, cultural diversity, we have Afro-descendant communities, indigenous communities, mestizo communities or mixed communities, and perhaps a little bit of white communities as well. So this combined opens the way for inequality, and we also are not, of course, a rich country, no? So and we are a country rich in biodiversity and natural resources. So the recent, like the last decades, law and policy has favored an extractive economy based on the extraction of minerals, natural resources. So this puts a lot of pressure on ecosystems and rivers. But we also have a very strong protection of human rights, no? So the balance between protecting ecosystems and protecting rights is in tension, and it has been in tension for a long time, since the creation of the Constitutional Court in 1991. So what happened with the case of the Atrato River, which is a ruling by the Constitutional Court of Colombia in 2016, right after in New Zealand they got the Wanganui Treaty, the Wanganui Agreement, is that Afro-descendant communities from the Pacific region of Colombia have had a long struggle with the state for the protection of the rights to health, to a safe environment, to land rights, most importantly. And their rights have been historically unprotected, or let's say they are not the most privileged communities. And in the context of this extractive economy, it's usually these communities, Afro-descendants and indigenous, who have more problems with the protection of their human rights. So they have brought many cases to court for rights protection, and one of them is not the only one, but one of them in 2016, yes, was about mining in the Atrato River, which is the river we've seen there. So there is a lot of gold in this river, and so there is a lot of legal and illegal mining happening. And because of the context of armed conflict, the state doesn't really have full presence over the national territory. So many illegal groups dispute the extraction of natural resources, or they have a presence in the territory as well. So these are some images of illegal extraction of gold in the Atrato River. So the river, the health of the river itself is really in danger, or is really harmed. And with it also the health of the communities. So the use of mercury for mining is the amount of mercury in this river is over anything we can imagine. This mercury goes to the fish. People eat the fish. People have a violation of their human right to health and life. But also the river itself doesn't look like a river anymore in some of the parts of where it flows. So the communities brought the case to the court using constitutional protection, and this time was special because the Constitutional Court said yes. So they declared the violation of the rights of the communities, but also in an unsolicited manner, they also declared that the river had rights itself. So it's different from the New Zealand case and a little bit from the Indian case, I guess, because this river is not a legal person, so it's not cannot have duties, no, which is an important part of this discussion, but it has the maximum level of protection, no, of its interest, which is the language of rights. So it is a subject of rights, but it's not a legal person. And it has 4 rights, constitutional rights, because there has not been legislation about it: the right to protection, the right to conservation, to maintenance, and to restoration. The meaning of these 4 rights is still, I mean, we're learning, you know, what's the meaning of this. There has not been a case where the river itself, as a subject of rights, comes to the court to ask for protection or does anything legal. So far what has happened is as a change in the way of arguing the legal protection of ecosystems in Colombia. So it's still hand in hand with human rights protection, but there is a shift in argumentation and probably in perspective on how can we use the maximum level of legal protection also to focus on the ecosystems themselves, no? So focusing not only on the health of the communities, which is a focus, of course, but also on issues like life cycles of biodiversity, of water, no? And an ecological balance or integrity of the river and ecosystems. So this is more or less a summary of the Colombian case, and I will be very happy to share more later. Thank you.
Thank you, Kathleen. I wasn't even half as confident as you while pronouncing my name. I was too scared whether I'm pronouncing your name correctly or not. Thank you. Thank you.